So we are synchronized. Welcome to the channel. I'm Matthew Mile Gray. Today what I thought we could do is we could catch up on the Norway Supreme Court and its dilemma with respects to a high control religion and what may be considered negative aspects. So there have been some concerns about reports of abuse and the pathway to persons reporting that. So you think about allegations, and you think about when abuse cases come up, say for instance like what happened in Pennsylvania with the high control religion Jehovah's Witnesses, and how you had some bad elements that came in and were using the religion or the religious freedom and the legal entities that the religion has at its disposal to actually in fact shield these abusers for a long time, so much so that the mayor's office had to intervene, and then of course convictions took place and that hit the news. So I want to just look at the Norway Supreme Court and the matter of the time that it's taking to rule on the state's dilemma, because there's something here. Whatever Norway Supreme Court rules, there is an important takeaway from this. And I thought, while time has gone by, we are now in April, and we are precisely, I've got to just open up my calendar to know what day it is, but it is 7th of April that I am reporting this. So making this video or just recording this video, 7th of April, that's the mark. We anticipating any day Norway Supreme Court can make its ruling, but bear in mind that it hasn't been a short process. This has been a long process here. And so this is what I thought we could talk about, because when it comes to a situation where you say a person now alleges that a crime has occurred or abuse has occurred in various forms, it doesn't have to be abuse of individuals. It could be a theft, for instance. It could be some kind of crime. But yes, Jehovah's Witnesses have come under a spotlight that there is this pathway where, the shunning arrangement, or if you want to call it the removal arrangement, or formerly known as disfellowshipping, has been used as a way to protect the religion from potential liabilities, because you could do something that is against the doctrine, but if you show a repentant attitude with commensurate works, you're still in the religion. You can still enjoy fellowship with the religious community. But when there is a potential liability, then your shunning arrangement or your tribunals or your disciplinary arrangements act as a firewall against potential liabilities. And that's what's been coming out more and more and more. But what's useful with the Norway Supreme Court case is you can see just how much time and how much energy is involved. And if you have persons that are disenfranchised, say for instance a child or parents or somebody that's embroiled in a dilemma situation, how on earth are they going to get justice? How on earth are they going to get the necessary protection that they sought to get from being part of the religion? These are difficult things to navigate. So what's the dilemma? We've looked at this on the channel, what the dilemma is. If you fund JW, and by the way, it's not just JW that's in this. The reason why it's taking so much time for Norway Supreme Court to come up with a ruling is it sets a precedent for other religions, high control institutions, high control religions, but specifically religions, because you have this freedom of religion that you're allowed to have, and it does alter the dynamics significantly in how you deal with it when there is an alleged crime that comes up. So Norway, if you fund JW, they are saying, oh, why are we in trouble? We're in trouble because it looks like our subsidy is supporting a bad ethical policy. Can't do this. What's the dilemma? What's the other side? If they withdraw funds, if they withdraw subsidy, it looks like discrimination. So it's the discrimination card that is being pulled. So many disenfranchised people, if I can just try and clarify here, in the JW system, that is my experience, and that could relate to other religious systems that use similar institutional shunning arrangements, not just individuals' conscience, though they frame it as, no, you have the right to shun a person if you're not comfortable. It's an institutionalized, arranged shunning that we're talking about. And that is specifically when it is weaponized or looks like it's used to prevent liability coming into the religion that's arranged this disciplinary action. So many disenfranchised people in JW, they find themselves in a catch-22 situation, a double bind. They couldn't get justice. It becomes intolerable psychologically. It becomes a mental torture, you could say. Persons can't get justice, and we're shunned, lose family, lose social standing. It has a massive knock-on effect. So how Norway, the state, the government, with all of its resources, all of its ability to go to court and hire the right kind of legal instrument, lawyers, with all of its resources, is on principle, not, we can't say feeling, we could say it's in the situation that many that are called ex-JWs or JW survivors or JW emergent, however you want to frame this, because I realize that the words or the name or putting persons into boxes can also be a triggering thing. So I say ex-JW, JW survivors, some are proud about bearing a name apostate, others are saying, no, I was always a believer, I was just pushed into a situation through my obedience that now I face these awful situations. So without trying to trigger anybody, I'm talking to persons that have familiarity with that system and have got sunburn. When I say sunburn, some kind of harm from the situation due to a double bind policy. So Norway, in effect, was put into a dilemma, though it doesn't feel like an individual doesn't have the feelings that an individual has, but it's answerable ethically as per the individual. But the individual has feelings and has a mind that can be hurt, has relationships that can be hurt. And so it's more complex for a person, but in a way, the state, if you treat it as a person, you have a situation where they're going, oh, well, you're now facing this dilemma situation that many persons who are trying to seek justice due to these impasses, these double bind situations where they locked into essentially abuse and further re-traumatizing. It's a very, very difficult situation. So it's been, I don't want to say, I want to say a clearer, more exposed case study of what's going on with Norway Supreme Court and the state. So the Norway Supreme Court, when you get your judges that are coming together and listening to this, they're trying to find where's the middle ground, and then they steer towards this side of where the middle is. So there's the two sides, thesis, antithesis, you could say, and there's the middle, which you could say imperfectly is the synthesis, and then they try to go towards the conservative side. That's the way it normally works. It acts conservatively past that middle. So Norway is taking its time. That tells you something. It usually means that the issue is genuinely difficult. If it's genuinely difficult for persons who are trained in this, imagine what it does to persons who don't have higher education, who've been compartmentalized, marginalized, and placed into a captive situation. So the situation is genuinely difficult at the level of principle. It's not merely administrative. So I hope that sounds sensible. So what it tends to show is this. The court likely sees or recognizes a real collision of rights and duties. Right? So the state has two duties. What are they? Well, don't discriminate against religion simply because its beliefs are unpopular. That's the one. The second one, do not subsidize practices that the state believes undermine the rights or welfare of citizens, especially minors or vulnerable people. Yeah. So that is a hard constitutional knot. So courts are often comfortable when one side is clearly unlawful. Yeah. So they slow down when both sides have a serious legal claim. So in plain terms, Norway may be feeling the same structural bind that many former JWs or emergent JWs felt. Like, how do I put this? If I comply, I violate conscience or safety. If I resist, I lose belonging, right? Or I lose standing, or I lose support, or I lose my intimate relationships with family, right? Which is denied in the front face of the JW religion. They said, no, that doesn't happen. But it does. And you think about this Brazil case that's happening right now, where there were cameras and they could see, this does happen. This does actually happen. It was the evidence that was elusive before. So in an environment now where there are more cameras, security cams, you can actually take a look and see that, innocents are involved. Children of persons who've made an ethical choice, they, suffer because of maybe what a parent has decided is ethically right in their free will. So it's such a complicated situation, and it's because you've got this institutionalized shunning. Not a person can decide that. It's regulated. It comes from your religious leadership. And again, the intention was to keep a congregation spiritually clean, but it looks like what's happened is it's more about protecting the institution or even individuals that have gained leadership roles who've sought that out to be protected. So they can do more or less whatever they want. And we say allegedly work above the law, use the religion as a front and use it as a shield. So that doesn't mean that the court is experiencing the same pain. It's not a person, all right? So in a personal sense, it doesn't apply. But institutionally, it's confronting the same logic trap. So the delay can mean that the court knows its ruling will become a template. It's got this awareness. So the Supreme Court of Norway does not just decide this case. It also carefully asks in the back room, in the consultation behind the scenes, it asks, what precedent are we creating for other religions? Because this is going to come up. It's not just JW. We recognize what we decide here is going to affect other institutions, and specifically religions. Starts there. If you've got governance that is intertwined with religion, the implications are massive. So governments are in this situation where they go, are we shaking our means of governance? Is that what's happening? Because if we have this relationship between government and religion to control people's minds, govern mentality, government, we've got to be really careful that we don't trigger something that's going to create chaos. So it's saying what's going to happen with our decision with respects to other high control groups. What happens for parental rights cases? For state funding generally. So the delay, from what we can see, may show that they're not only judging Jehovah's Witnesses, but also trying to avoid accidentally writing a rule that later protects abuse or allows ideological discrimination more broadly. So that's why top courts move cautiously. A bad precedent can do more damage than one bad party. So yes, Supreme Courts often look for the narrowest statute, okay, the middle. So if you're reading that as it's trying to find the middle and then be conservative on the one side, that's kind of the direction. I realize that's imperfectly said, but yeah, if you're reading that in this way, it's broadly correct. It's broadly right. So many apex courts do tend to find that middle legal principle that can survive the scrutiny. So they are trying to avoid overreaching and then rule conservatively, just beyond that midpoint. Okay, not because they are, how can you say this, morally lukewarm, right? But because they are trying to make a judgment that lower courts can apply, and so that governments can administer. And so future litigants, can we call them that, cannot easily weaponize, because now what if you have a situation where you've got a bad player, all right, that isn't an innocent victim, but that is getting vindictive with your institution? What about that? Perhaps in the way that I've been framing things on the channel, it's all about, but what about an innocent that's abused by a leader? What if the institute had legitimate cause for removal and the person's retaliating, bucking against law and order? You don't want to now enable that from happening. I mean, that's the other side. So very tricky stuff. And so, what are we looking at? We're looking at this situation in Norway that produces judgments, or is hopefully going to produce a judgment that feels frustratingly restrained, to survivors of injustice, because courts usually do not say everything that is morally true. They ask instead, what can we prove? What can we define And what can we enforce in law without breaking the wider legal framework? And so this is much narrower than justice in the human sense. So the court may be wrestling here with the difference between belief and conduct. So that's usually the core of what's going on, because a court is more hesitant to punish doctrine. That's a problem. Scriptural interpretation, no-go area. Internal theology, no, can't do that. That's freedom of religion. But a court is more willing to regulate coercion or how a minor is treated, or exclusion from family, social life, realistically, when it causes measurable harm. So you've got, in a worst case scenario, an elder or a leader that's created the harm and either chickened out, made a mistake, or it was deliberate, this kind of situation, and then using the system to try and shield themselves. And it's just like, man, how do you sit with a hypocrite? It's very, very difficult. Very, very difficult. If they're calling the shots, it becomes intolerable. Even if the top of your mind says, I can rationalize it, your subconscious just goes, no, can't. It's the 1,000 paper cuts. You bleed out. So the real question might be something like, can the state deny funding, not because it dislikes the religion, but because certain enforceable organizational practices conflict with the civil values, especially those that are required for public subsidy, to say, here's some cash, off you go, you're doing a great job, please carry on. That's a much tighter and more legally durable question than, say, for instance, is this religion good, is it bad? Nah, that's, steer away from this. Courts try very, very hard not to become theologians. It's not their role. So if Norway is taking its time, it may actually mean that, ex-JW, JW emergent survivors argument has serious weight. In fact, in my opinion, I'm going to say yes. That's my finding. That is my opinion. I go, yeah. And I don't believe I'm isolated in that opinion, although please prove me wrong. Not automatically that, Norway State will win here, but that it cannot be easily dismissed as mere bitterness or fringe grievance. No. That's not what we're talking about here. And that's what this is exposing. It's exposing that with people, wait a second, this isn't that they got their hand caught in the cookie jar when they were told don't touch the cookies. This is because somebody has a genuine grievance. I don't know if that's getting clearer. I might have got that a little bit muddled in the way I presented it. But instead of like ex-JW community or JW emergence being just labeled as lousy people, that want to just punish the institute that punished them, it's showing up that there was legitimate cause. The fact that Norway is taking so long, that's our takeaway. Because if a modern state with lawyers, ministries, judges, there you go, there's the resources, appellate layers, is still stuck on the same dilemma, which, according to the date, I haven't seen anything. If you can see something, say to me, Matt, you missed it. They've made a ruling. It tells us something important. It tells us the problem was never just a few oversensitive, disgruntled people, which is the way it's been presented, much to the dismay of somebody who's trying to find justice, who has a legitimate case. It suggests that there is a real structural, ethical problem embedded in the system. And that's the significance. It's very, very significant because courts often move slower, exactly where survivors want clarity the fastest. We've been waiting 10 years. We've been waiting 20 years, for justice. So that's the tragic mismatch. I mean, they say with abuse survivors, what is it, 26 years before they come forward on average, So people harmed by a system often need a court to plainly say, yes, this was coercive. And it's like a relief moment. What did they just say? Did I hear that correctly? The court says, yes, this was a double bind. What, really? Or the court says, yes, exclusion became or can become abuse. And it's like that relief moment. You go, am I in a dreamland that I've just heard that correctly? Here's the reality about Supreme Courts. They often, can I say allergic to broad moral language, unless they can anchor it very tightly in law. So even if they see the ethical reality, and I believe it at that particular case, just listening to it and watching those 3 days play out. Yeah, it's still, you can see the court, the reason why it's taking time is because there's this situation where what can I say? A narrow ruling about registration or subsidy criteria or administrative legality or proportionality or freedom of religion, right? It might feel bloodless, but it matters hugely. So how do I make this into some kind of sober reading? If Norway's top court is taking its time, it likely means that some combination of the issue is legally and politically consequential, right? I want from the chatter, I believe that that's been recognized, right? And the judges know whatever they say will echo far beyond Jehovah's Witnesses, goes into governance. They're going, are we shooting ourselves in the foot? Are we shooting the state right in the foot? Because, the way that we have power is through religion, largely. So they're trying to separate legitimate religious freedom from publicly subsidized harmful policy. So they don't want to be reckless here and go, okay, right, now, Norway is anti-religion. It's a precedent that's looked at as reckless. Abuse gets immunity. It's called religion precedent. I mean, that's the other side, right? So it's not trivial. It's not trivial. Do we enable bad policies by giving the subsidy? Are we called anti-religion because now we've withheld it? Yeah, it's a mess. I think that has been very clear, right, through the way we've been examining this. So yes, the point is becoming stronger when we look at it this way, because a system that trapped ordinary, I'm going to say members, associates, right, in a no-win ethical bind, like Australian Royal Commission highlighted, said, oh, this looks very much like a captive system. Norway's in this no-win ethical bind. That's what the people have faced, right? That's what they're saying as they come forward. And they're saying, oh, isn't that interesting now? You've got a government that's facing the same thing as the people have been complaining about. But are you the bad guy now? Is that what's happened? Are you labeled satanic? Are you labeled terrible because of this? So it's not proof in itself. but it's morally revealing what's going on. And here's the caution. The caution is that courts sometimes take a long time, not because they are deeply wise, but because they're trying to avoid owning the full moral implications. So the delay is indicating the seriousness of the situation. But sometimes it's also institutional discomfort. All right? So, maybe we should ask the question, has Norway made clear to discerning observers the dilemma? Is it clear? Because we heard dilemma. We heard it, right? But is it clear as to what the dilemma is? That it's talking about when a religious institute, high control institute, creates policies that shield actual crimes. Right? Takes a very, very long time. Or you have civil cases, takes a long time, or it just goes nowhere, it's polarized, or it just comes to an impasse. And you have bad players that use the religion as a front. It's the policy has created this front for bad actors, okay, who seek leadership positions. Let's get into it. Let's get a clique going. And maybe those religious leaders don't even respect their own doctrine. This is also what's coming out, I believe, in the chat I'm seeing. No, we're getting reports that persons in these top tiers, they don't even believe. They don't. Right? They don't follow it. They've got this fluid means of functioning. Right? Liberal even. So they don't respect their own doctrine of the religion, but are hiding behind the religion's legal might. So I don't believe there's a short answer. It's not clear in that full systemic way, at least not publicly, in the legal framing that we can point to with confidence. That's why it's got to this stage. But what Norway has done, in effect, is pointed towards part of that problem by focusing on how certain internal practices can harm rights and welfare, especially around shunning, which... What did they say in the case? Even though Jehovah's Witnesses, Jehovah God uses the word shunning, right? That's an apostate teaching. It's so clever, isn't it? These things. But anyway, look. Shunning. Exclusion of minors. That's the pivot point. So the important distinction, as we try to get clarity, what Norway appears to be saying, or the state's case is publicly described, has mainly been upon the lines that, oh no, we're not banning your belief. No, that's not what we're doing. We're just questioning whether public subsidy and legal recognition should continue. If certain organizational practices conflict with the values and protections that the state expects, or that is expected for the state to adhere to from, say, for instance, I don't know, European Union, something like that. But let's say a watchdog entity that's saying, hey, you've got to watch your ethics here. You've got to make sure that when it comes to these double bind situations, you have resolved this thing correctly. So the broader claim, rather than this narrow claim, right, that this religion creates cover for predators or abusers or manipulators and bad faith power seekers. It may be morally or sociologically plausible in some cases, and how do you measure this? But the state and the courts are usually very careful not to frame things that way unless they have specific evidence. And that's, again, a catch-22 situation, because who comes forward with the evidence? Who's equipped to bring up all the evidence? You have to have cameras around you 24/7 to be able to record this kind of thing, which is why in Brazil that's an interesting case, because they did have the cameras to look at what was going on. It looks like you've got more discerning observers now. This is what's happening, and they can still see the deeper pattern. That's why Norway taking its time is still of benefit towards justice seekers. Why? Because a discerning individual or observer or group of individuals could reasonably infer that high control structures can unintentionally or intentionally create shelter for bad actors. This is why I say sometimes we've got to make clear negative high control religious situation, so that we're not putting a blanket statement here. It's very important. Why? Because systems with these features are often vulnerable to misuse. You've got strong obedience culture, okay? Reputational protection of the institution. You've got internal handling of misconduct, okay? Pressure not to bring reproach externally. Fear of social loss for complaints or complainants. Deference to male elder authority. Punishment or marginalization of dissenters. And so when those conditions exist, they can create a situation where sincere members are trapped. That's what Australian Royal Commission was talking about when it said captive situation. So conscientious objectors are penalized. Somebody who's obedient in that system, just gets into trouble because it exposes the flaws in the system. And then you've got the opportunists. The opportunists can hide behind procedure, doctrine, legal defensiveness. They get their click. That is not unique to Jehovah's Witnesses, by the way. I think we have emphasized that. It can happen in religious, political, educational, corporate, and activist systems too, even in what's supposed to be a healing network. Guess what? Happens there as well. So, it's serious stuff. So, has Norway made it clear? Have they? I think I would put it this way. Norway has likely made clear that the state believes some JW practices may conflict with civil protections and public values. So the state doesn't want to financially endorse practices it sees as harmful. Norway has not necessarily made clear and explicit legal language. It's very difficult to do so. It can't say, that the structure can act as a shield for criminality, okay, or civil wrongdoing, or that some people may pursue leadership precisely because the structure often covers, their I want to say modus operandi or whatever they're doing, right? That's not cool. And so it's that second level that's often understood by survivors, the emergent or ex-JW community, long before institutions are willing to say it aloud. So why institutions avoid saying the deeper thing directly? Because once a state says, your structure can shield abuse or attract bad actors, it enters into a much more explosive zone legally. Yeah, you've got defamation concerns. You've got new problems coming up. It's going, we don't want to get into that. Or what about evidentiary burden? Going, our resources are spread thin, religious freedom scrutiny, human rights appeals. I think do we separate that? So we could say religious freedom scrutiny. We can say human rights appeals. We could separate that. But it also converges, right? So yeah. And then you've got a precedent for scrutiny of other groups as well. Okay. So governments often argue the case through administrative, child welfare language, even if the underlying concern is actually much bigger. So that can feel frustratingly sanitized to survivors, because it sounds like, oh, we've got concerns about procedure, when what many who are harmed, when what they are hearing is they're saying, oh, this structure can break people and protect the wrong ones. How do you sit in that environment? How do you go, oh, yeah, sure, I'm going to take orders from this person that's in oversight? It's just going to be conflict. Your subconscious is just going to assert itself and go, nope, and then you look like the bad guy. So is our insight becoming stronger? Because this isn't a trivial thing. A system doesn't have to be founded by criminals to become useful to them. Remember, I'm aware that that's a tricky statement. It's one of the hardest truths for an institution to face. Because a structure can begin with sincere beliefs. Yeah, let's take it that way. And still, over time, becomes attractive to controllers, image managers, manipulators, cowards, moral cowards, or people who enjoy authority without accountability. So if the system also punishes whistle-blowing or conscientious resistance, then it becomes a double-bind machine. That's it. And that's exactly why survivors often sound too intense to outsiders at first, because they are trying to describe a structural reality, while the institution keeps presenting itself as a matter of it's mere doctrine or religious freedom, folks. We talk about sober answers. Excuse me. Sober answers. I would not say that Norway has fully and openly articulated the whole pattern as sharply as, some could say. But I would say this. Norway's case has helped to expose that the issue isn't merely theological, right? But whether an internal authority system can produce civilly harmful outcomes while claiming religious insulation. And that's a very important shift. Very important. And once that principle is admitted, you get a harder follow-up question, right? And it's natural. It's natural to have it just appear, because when does religious autonomy stop being protection for conscientious, or I'm going to say genuine people, who are exercising their conscience according to ethics, and when does it start becoming a cover for unaccountable harm? I tend to suspect this is one of the real questions underneath all this. So, if you're thinking, well, Matt, where is it clear that Norway has an actual dilemma? Yeah, we heard the word dilemma. But where is it clear as to what the dilemma is, where subsidy would facilitate harm, and if they withdraw that subsidy, then okay, now it's discrimination, right? If it's not clear, then you could say technically there's no problem. Stop wasting our time. Some police have done that. Stop wasting our time. But now it has got to a Supreme Court situation. So they're trying to resolve this. That isn't wasting time. They're going, no, there is a problem here. We're seeing it more and more and more. So where is that clarity of this dilemma excuse me, existing? If it's not clear, if it's not a clear ethical problem, why has it even got to this level? So that's why I say the fact that it's taking this long, there's already useful takeaway from this whole scenario. Okay. Because we want to talk about survivors. We want to talk about survivors of harmful, captive, high control cult religions who are seeking justice. And so now you've got to get the clear distinction, because if the dilemma is not sufficiently clear in law, Norway may still lose the case. But it doesn't mean that there wasn't a real problem. It doesn't exist. No real problem here, folks. Nothing to see, nothing to see. No, it doesn't mean that. It means something a lot tighter, a lot narrower, and more frustrating. It means something like the harm may be ethically real. And when it comes to experiences, you say, no, I validate what you faced. It's real. Okay? And yet it's still difficult to prove or define at the legal threshold required to deny state subsidy. And let's get it right. That's exactly where many survivors have lived for years, decades. So, Matt, where exactly is Norway's claim dilemma actually visible? Does it exist? Yeah, it's visible. It's visible in the state's own legal theory of the case. Wait. What did you just say? Theory. Matt, did you just say theory? Yeah, I did. So the clearest official public summary that I could find is from the Norwegian Supreme Court's case page itself. It says, okay, the case is about whether Jehovah's Witnesses' practices violate the right to free withdrawal, right? And the rights of children, right? Under the Religious Communities Act. And that's what matters, because it tells us what Norway says the problem is. We don't have to be confined to what Norway is saying the problem is. Don't have to be. But the way I started this off, I was talking, well, let's see what this time is all about. What is it teaching us? What is it showing up? Because Norway's apparent position is roughly, if a religious group receives public money, that's the issue. But its internal practices materially obstruct free will in exiting. Yeah, that's it. Okay, it's the exit point. Or it harms children's rights. Then the state may be helping fund a structure that conflicts with the very rights the state is supposed to protect, and then it loses its power there because your public confidence evaporates. So it can't do that. That's the dilemma. So yes, that's the real conceptual dilemma that is on the record. But the dilemma being conceptually real is not the same as it being legally proven enough. And that's why this reached higher courts. Okay, because the real fight is not, is there any concern at all? The real fight is, has the state shown enough in law that these practices cross the line, folks? You know, from protected religious autonomy into subsidy disqualifying harm. That's why it's such a hard question. The whole case turns on threshold, and that's the word underneath everything, because a court can agree that, oh yeah, shunning's harsh, we see it. Social pressure, yeah, it's real, got it on cams, you know, cameras, yeah, we see it. Children may be affected, yeah, got it. Leaving can carry major relational cost, and still say it's not enough legally. It's not enough for the state to deny registration or funding. And that seems to be the real tension. You know, that's visible to, you know, you start opening appellate history. You start observing this. So, for example, the Court of Appeal apparently ruled for Jehovah's Witnesses in 2025, right? While still recognizing that the case involved questions around free exit, okay, and children's rights. Yeah, we got that, Matt. Then Norway appeals, and the Supreme Court accepted the appeal, which usually means it sees an important question of principle worth deciding. They wouldn't have done this if they didn't see it. They wouldn't have allowed it. That's what's revealing here. Because it means that the legal system itself is not saying, oh, nothing's wrong. No, nothing to see. No. It's not saying nothing's wrong. It's saying we are not yet settled on where the enforceable line is. That's very, very different. So if the clarity is incomplete, what legitimacy does that give survivors? A great deal, actually. Surprised? Not because survivors are automatically right about everything, but because this situation demonstrates a crucial truth, that a harm can be real before institutions are able or willing to name it clearly. And this is one of the oldest patterns in justice. Think it's new? No, it's not. Because your examples across history, you see coercive control and domestic abuse. You see it in spiritual abuse. You see it in workplace psychological intimidation. Yeah, it's happening. Institutional grooming environments. Persons who say, oh, I was born in. Were you born into this religion? I was born in. Didn't know any different. Thought it was all, you know, tickety-boo, wonderful. This is your institutional grooming environment. This is your emotional abuse of children, non-physical systems of domination. This is it, you know. So in many such cases, survivors know what was happening long before the law had the vocabulary, confidence, or proof structures to address it clearly. And this matters enormously because things are closing in. It means for maybe now, maybe, a lack of neat legal clarity is not proof of lack of harm, but I would say it's very close. I would say you're at a tipping point, because sometimes it is proof that the system of proof is lagging behind the human reality. That's why you can have companies, operators doing whatever they want for, years, maybe even a decade before, things catch up with them and they get imprisoned or they get the penalty or, comeuppance. Whereas if you, fail to, pay for your parking for your vehicle, you get a swift penalty. You're going, what gives here? So that's exactly why survivor testimony matters. That's why it's important to have healing networks, because what Norway, in its state dilemma, does, whether Norway wins, whether it loses, is it shows that the survivor's claim is not inherently irrational or fringe. Why? Because now a modern democratic state with ministries, lawyers, administrative review, trial courts, appellate courts, and a Supreme Court is tied up over the exact issue. Yeah. So can internal religious discipline become coercive enough that the state should not materially endorse it? It's not a trivial question. We said this. And once that question is serious enough for a Supreme Court, survivors gain something very, very important. Epistemic legitimacy, meaning, Matt, these long words. Here's the attempt to define. What we're describing was not just personal oversensitivity or bitterness. It was serious enough to become a constitutional level public question. And that's very, very meaningful. It's a meaningful form of validation. And I believe that that's coming through. Even if the legal outcome is missed or it's disappointing, people go, why'd we go through all this? The deeper truth that courts often need is clean categories. Okay, but high control harm is very, very messy. That's what we've learned. All right, that's the case. And so this is where survivors are often ahead of the law. Did you catch that? They're ahead of the law. Because high control systems often operate through conditional belonging, induced fear, anticipatory obedience, reputational threat, family leverage, conscience traps, social death without formal physical force, although, that can be there. So that kind of harm is very real, but often it's hard to litigate because it's partly voluntary on paper, or relational rather than overtly physical. Although you can argue that, that comes in. It can be spiritually justified. This is like, we don't, how do you prove that? Or it's unevenly applied. And it's easy for institutions to reframe as personal conscience or religious discipline. So a court may struggle to say, this is legally coercive enough. Even when many survivors know full well, the system trapped people, And the mismatch, it's tragic, but it's common. So does Norway's difficulty strengthen survivor legitimacy? Yes. Yes. In 3 ways. It shows that the issue is structural, not just anecdotal. So it's no longer just, one bitter ex-member, XJW, apostate, or somebody who's lost their mind, mentally diseased, who cares, No. You can't just say that this is isolated family disputes, no, or hurt feeling over doctrine. We're already seeing past that these things were not about doctrine. These were also people that obeyed doctrine that got into trouble. And it's become a state-level governance problem as a result. And that's what matters. That's the takeaway, because it shows the harm question survives, even where the legal answer is uncertain. And that is so important, because a court can say, oh, we're not satisfied that the statutory threshold is met. It's not the same thing as saying, oh, the survivor account was false. It may only mean that, okay, the law is currently framed in this particular way. It doesn't capture this well enough. That's the situation. We've seen that. It's not capturing it. Okay, that's the Brazil case that's happening now, because they did capture it. They saw it. So that distinction is very, very big. It's often missed. We live in an environment with webcams, cell phones, cameras are everywhere. And so it exposes a recurring injustice that survivors know well. That if the harm is too soft to count, the institution remains protected. It stays that way. So if the survivor reacts strongly enough to be noticed, the survivor gets called unstable. Oh, no, you're bitter. No, you're extreme. Another catch-22 situation. And Norway's case has, in a strange way, made that visible. Yeah. So, are we coming up with sound logic now? With refining this through examination? Because you might say, well, if the dilemma isn't clear, technically there's no problem. No, stop. It would be better to refine it to, if the dilemma is not clear enough in law, technically there may be no legal, I want to say actionable and connect legal together, but legally actionable problem under that statute. Okay, but there may still be very real ethical, social, psychological, and civic problems, and that's the painful gap. Yeah, that gap is exactly where many survivors have been abandoned. Did we say that, we're coming up with sober conclusions? Yeah. Because Norway's case gives survivors something important, even before final judgment. We mark the date here. And maybe this video is ephemeral, but let's just mark it today, before it happens. Because it demonstrates that high control religious harm is serious enough to force a democratic state to wrestle with whether public money can help sustain it. That doesn't guarantee legal victory. Sure, got it. Okay, but it does undermine the old dismissive line that, if this were really abusive, the authorities would obviously have done something. Now, the authorities are struggling with it. And their struggle itself is the evidence that the issue is not imaginary. That's our takeaway. So I want to thank you for joining in, coming and visiting the channel. I want to say thank you to friends and family. Of course, please broach this subject with the usual essential critical thinking thesis, working thesis with antithesis for synthesis and a healthy skepticism. And I want to say again, I deeply appreciate the support and the participation that comes in, that helps to make these videos come through like this. We are making significant headway to healing people. It is happening. And so I want to say, you are the reason we are here. This is Matthew Milo Gray saying, please go well, keep safe, and let's keep moving forward together. That's it. Signing off.